We are excited by the turnout of over 260 people for today's call. There is clearly a strong interest in the topic. Let me start by introducing myself and the work of the Southwestern PA Housing Alliance and the Rental Housing Work Group. My name is Gail Schwartz, and I am the coordinator for both the Southwestern PA Housing Alliance and the Rental Housing Work Group. Convened by the Southwestern PA Housing Alliance, the Rental Housing Work Group is a coalition of organizations and individuals committed to expanding affordable, quality rental options for individuals and families who face barriers to housing. Using collaboration, coordination, education, and risk management, we bring nonprofits together with rental housing owners and managers to advance the goal of a home within reach of every Southwestern Pennsylvanian. In November 2014, the Southwestern Pennsylvania Housing Alliance hosted a roundtable to jumpstart a conversation among housing and homeless organizations in the greater Pittsburgh area that are actively engaging the private rental market as a resource for people in need of housing. Based on the success of that event, the Southwestern PA Housing Alliance convened the Rental Housing Work Group to build new partnerships between nonprofits, housing authorities, and property owners and managers to expand the use of beneficial resources such as PAHousingSearch.com. Today's webinar is the second in a series specifically designed by the Rental Housing Work Group to educate private market landlords on available community resources and how current humanitarian efforts can also meet their needs along with the needs of their tenants. Typically, we advertise these webinars to the greater Pittsburgh area only, but we thought since we were discussing state law today that we would open it up to the entire state. We are very glad we did because I think we have record-breaking participation. So now I would like to introduce our presenter, Dan Vitek from Neighborhood Legal Services Association.
Hello, everybody. Again, thanks for joining us. I'm excited about the turnout as well. My name's Dan Vitek. I'm the Senior Housing Attorney at Neighborhood Legal Services Association in Pittsburgh, Pennsylvania. I've been a practicing attorney for just over 7 years, and since 2012, been the Senior Housing Attorney here. Our organization represents tenants, so a lot of the information that I'll be presenting today, although focused on what a landlord needs to know, will be coming from my perspective as someone who's litigated a lot of cases on the tenant side. Hopefully you enjoy it. And feel free to add questions as I'm going along on the little chat section, but mostly questions should be reserved for the end when I hope to get to everything you guys have to ask. All right. Today's agenda, we're going to first start with what laws apply and when, and what are we talking about when we discuss landlord-tenant law. Then we'll get to reviewing the lease and various terms within the lease. I'll briefly touch on security deposits because that seems to come up quite a bit. And then finally, we'll discuss recovery of the property, the eviction process, when things don't go well and you need to remove a tenant. All right, so what are we talking about when we talk about landlord-tenant law? Well, landlord-tenant law is really the specific rules and requirements that govern a landlord's relationship with his or her tenants. And this law applies when there is what we call a landlord-tenant relationship between the owner of the property and the individual occupying that property. If the landlord-tenant relationship does not exist, then the special protections and the various rules that landlords must follow do not apply. So let's first address when does a landlord-tenant relationship begin. There's no definition as to what a landlord-tenant relationship is under the law. That was left out of the Pennsylvania Landlord-Tenant Act. The courts have really established that you look at the circumstances, not just what the parties have stated their relationship is. And the main thing that the court is going to look for is there a lease? And remember, a lease can be written or it can be verbal. It also can be based on an expressed agreement between the parties or an implied agreement, meaning that you'd never said, okay, this house is yours to rent and you'll pay me this much rent, but that you let someone move in and they began paying you rent. That is going to be an implied agreement. The court also looks at other things. You know, are you having the tenant pay rent? Does the tenant have exclusive access to the residence? What's the purpose of the tenant's occupancy of that property? Is it to live in, or was it for storage or business? You know, those would be alternatives to a tenancy. And then, are there services provided? You know, beyond a roof over your head, beyond the actual possession of the property, are meals provided, are drug treatment provided, etc. That would take you beyond the realm of a landlord-tenant relationship. Just do a quick side note on a few things that come up that are not landlord-tenant relationships. Land sale contracts. This is where the owner of a property sells the property directly to the buyer. There's no mortgage, there's no bank. And often what happens is the buyer actually gets to move into the property. So they're occupying the property as they're paying off the purchase price month to month. That is not a landlord-tenant relationship. And therefore, the protections of the Landlord-Tenant Act do not apply, but also the benefits, the expedited process of eviction does not apply when things go wrong. Guests, like family members, these are people that you're not having pay rent, that you've welcomed into your home for one reason or another, and then, when they're no longer welcome, if there's no landlord-tenant relationship there, in other words, you're not having them pay rent, there's no lease, things like that, then you don't have to go through the landlord-tenant process. Those individuals are not afforded the protections of a tenant. Boarding houses, inns, hotels, nursing homes, things like that, also not covered under landlord-tenant law. But remember that the court is going to look to the circumstances of the relationship and not just how the owner is defining the housing situation. So a lot of times landlords want to establish that they have a boarding house, maybe they have multiple tenants who have a common kitchen and bathroom, and they want to avoid the landlord-tenant process. Unless they're complying with the local ordinances for boarding houses and that they have specific information to comply with the innkeeper's law, they're not an actual boarding house. And I think most courts are going to run right past that owner definition and require the owner to pursue a landlord-tenant eviction. All right, so moving on. Once you have the landlord-tenant, once you actually have the landlord-tenant relationship established, what is the law that you're going to be concerned with? Well, there's the federal and state constitutions. There's federal law. There's state law. There's common law. That's when the court makes decisions that everybody has to abide by. Then there's the local government, municipal ordinances. And, of course, the big one is the contract, also known as the lease. That is going to be the biggest issue that you run into when you're looking to define what the actual rights and regulations are for your tenant. Okay, just quick to run through those. The state and federal constitution doesn't come up all that much in this respect. They're mostly concerned with due process of law, which comes up. Now, self-help evictions are illegal. We'll get into that in a little bit, but that's because if you are to remove a tenant from your property without going through the judicial process, you're not giving that person their constitutional due process. Freedom of association can also come up as an issue, particularly in subsidized housing. Then you have federal law. I put the two big ones down here that apply under federal law. Fair Housing Act, also the Americans with Disabilities Act, the ADA, both of those generally apply in one way or another to the landlord-tenant relationship. And they're very powerful acts. We'll talk about them a little bit later in the presentation. But that's something you have to be aware of in Pennsylvania, even though it's a federal law. The other federal law that really comes into play in every landlord-tenant relationship is the Residential Lead-Based Paint Hazard Reduction Act, which was signed into law in 1992. We will talk specifically about that act later on. Other than these two acts and a few consumer protections that the federal law provides, federal law really doesn't come into play unless you're in federally subsidized housing or you're renting to a tenant under the Section 8 voucher program. We're not going to get into that today, but you should note that there are specific rules developed by HUD, which is a federal agency, for how your relationship would work with that tenant. Okay, state law. Of course, the big law that you have to look to is the Landlord-Tenant Act of 1951. That's been amended a few times, but that is the act that broadly defines the rights and requirements of a tenancy, and you're going to have to follow all of those rules. That does set out certain things that are non-negotiable, that you can't negotiate in the lease. It also sets forth the process for eviction, and we will get into that later. Pennsylvania law also has some general consumer statutes you should be aware of. The first one is the Plain Language Act. That's an act that requires consumer contracts, like a lease, to use plain language. Fair Credit Extension Uniformity Act is a, unfortunately, strangely worded act that really means that you can't collect a debt from a tenant using deceptive or unfair methods. And then there's the Unfair Trade Practices and Consumer Protection Act, which is really an affirmative act. It allows individuals who feel that they have been cheated in one way or another to go after the individual who cheated them when it's a consumer relationship. And it's been a long time now that the courts have defined a landlord-tenant relationship as a consumer relationship. So that act is something you have to be aware of, but hopefully you won't commit any of those violations. And then finally, the Pennsylvania Human Relations Act is also important here. It really mimics the federal Fair Housing Act and Americans with Disabilities Act. So there's not much difference there other than it's applied slightly more broadly. And in Pennsylvania, the federal law is really going to be enforced by the state agency, the Pennsylvania Human Relations Commission. They're the ones who will do investigations for both violations of the state law and the federal law. Then you can't forget about local laws. Depending on which municipality or borough that you're operating in, you're going to have to make sure you understand what those local rules are. There's tenant registration requirements if you're going to rent out your property in some locations. There's, of course, zoning and building code enforcement that you have to comply with. And now more and more you see municipalities creating nuisance tenants laws, which are, generally speaking, require the landlord to proceed with eviction if there has been too much disruptive activity, such as a call by to the police about the property. And that can be, those laws really are pushing back and making the landlords be proactive, which they should be anyway, but this is something you have to be aware of so that you don't get caught up or the costs aren't placed on you when the municipality proceeds with the eviction on their own or penalizes you for not proceeding yourself. All right, I already mentioned common law decisions by the court in Pennsylvania that set forth some rules. The one big case is called Pugh v. Holmes. You should all be aware of it if you're a landlord. And this case says that in every landlord-tenant relationship, there's an implied warranty of habitability. This means that the landlord has to provide the tenant with a habitable home, a safe, secure, sanitary home. That cannot be waived through the lease. And so if you're wondering, who's responsible for the work to be done at the property, we'll get into that a little bit more when we talk about specific lease terms. But this case is really a broadly applying case that establishes that it's the landlord who has to provide, at a bare minimum, a habitable property. All right, so finally, as I said, the lease, that's really the most important legal document that defines what the rights are for the landlord and the tenant in any particular situation. And the lease is really nothing more than a contract between the two parties. So you're going to look to Pennsylvania contract law. And I'll point out as we go into the lease provision portion of this presentation where that makes a difference to you. All right. So what makes a lease? Well, again, a lease can be either expressed or implied. It's going to be up to the court to decide whether there's actually a lease in place and what the lease provisions are. A lease cannot be entered into by anyone in Pennsylvania who doesn't have capacity to enter into a contract. So that's, again, contract law coming in here. For instance, Pennsylvania, you have to be 18 or over to have capacity to enter into a contract. Also, someone who is no longer capable of making decisions for themselves, they might be found to be without capacity to enter into a contract. Just something to keep in mind, because those contracts would be void if it's found that you entered into a contract with a 16-year-old or something to rent a property. Not that that happens very often. But remember, a contract doesn't have to be in writing. It doesn't have to be signed. So in Pennsylvania, a lease can be written or it can be verbal. Either type of lease is just as effective under the law. Now, oral leases do have their problems, and I certainly recommend against entering into oral leases. The law will impose certain requirements on an oral lease that are beyond your control. For instance, you can't have an oral lease that goes over 3 years. Also, you can't waive requirements such as the requirement to give notice to quit to a tenant before you evict them. So when you do an oral lease, some of your control on the situation is taken away from you. Also, it's very difficult to establish clearly to a court what the terms were, particularly if you have a difficult tenant who disagrees with how much the rent was or how long the lease was for, who was supposed to pay for utilities. And when it's unclear, the court is going to step in and decide what they think the parties agreed to, and they're most often going to look to the actions of the parties, which can cause you some difficulty if you disagree with how the court interprets the situation. So, of course, I recommend a written lease. And now I'd just like to go through a few things that are important, in my opinion, regarding written leases. We could spend quite a long time teaching you how to draft every different provision of a lease, but we don't have that time today. So I'm just going to go through some pointers that I think draw out issues that are common or that I've seen in the past. First of all, you want to clearly define the terms of the tenancy in your written lease. That starts with describing the property that's to be rented. What's the address? Also, what is the access of the tenant to certain common areas like a basement or a detached garage? If you don't define these things, then you're going to get into a situation where the tenant is using space that you might not want them to use, but how are you going to control that if it comes to a situation where you have to evict them over it? So begin with clearly defining the terms of the tenancy. And this brings up a particular Pennsylvania law that I already mentioned, the Pennsylvania Plain Language Act. Now, like I said, this law applies to all tenant-landlord leases. And what that law says is you must use short words, sentences, paragraphs. You can't use technical language or legal language or archaic terms. I list two examples here just real quickly. For instance, the normal sort of everyday term is responsible. The legal term is liable. You can't use the term liable because a tenant might not really understand what that means. Same with a common phrase, right? If you want them to sign below, you just said person signing below. You don't want to use terms like undersigned. Now these two examples are fairly minor. I'm not sure they're going to create much of an issue if you have a lease that uses them, but the Act will void clauses that are too confusing to a tenant or that use archaic terms, technical language. So you want to avoid that, particularly in any form lease that you might have pulled off the internet or been using for a long time. You want to double check that you don't have any of those confusing terms in there. And then I also generally recommend that you have both parties sign the agreement. Like I said earlier, you don't have to have signatures to make a valid contract, but that really does put the tenant in a position where they can't deny that the document you have to present to the court, if it comes to that, is an accurate representation of what the parties agreed to. And that's really what you're trying to do with a written lease, is make an undisputable document that defines the terms of your relationship with your tenant. And remember, always provide a copy of the lease to the tenant and keep a copy for yourself. That's just common sense, but it really is going to make it a lot easier for you if there's a dispute, that you can refer the tenant back to that document. All right. As you all know, many written leases can be found online. A lot of form leases are already in use today and just passed down from landlord to landlord. Be very careful when using these form leases that the terms are specifically drafted to your needs and your situation and are consistent with Pennsylvania law. For instance, it is a violation of the unfair trade practice to have a confession of judgment clause in your lease. Now, what is a confession of judgment clause? That's an old practice that used to be allowed under state law that would allow you, instead of having to go to court, this term was in a contract, you could just go into court and file some paperwork and end up with a judgment, allowing you to, in a lease situation, go ahead and evict the person or get a judgment for unpaid rent, etc. That type of legal proceeding has been declared unconstitutional, and then the state went further and actually codified that those clauses are an unfair trade practice in the Consumer Protection Act. So a lot of older leases do still have that archaic term in there. And if someone wants to go out and get themselves a plaintiff's attorney, they could sue you for that violation. Also, it's something that is confusing because you might think you can avail yourself of it since it's in the lease, and you can't. So you just need to take it out. But that's what I'm talking about when I say you need to go through these form leases and make sure they comply with Pennsylvania law, that they're in plain language. As I point out here, that the Attorney General's office will actually review your lease for you and give you an approval that the language complies with the Plain Language Act. That can be helpful. It's a time-consuming process to a certain extent, but if you have a lot of properties and you're concerned about the lease you're using, you should submit it to the Attorney General's office. And you can go look on their website for how to go about that process. All right, just a quick side note on making changes to a written lease. Now, most written leases are going to be typed or printed out. And so if you have a handwritten change, you want to make sure that you have the tenant initial next to any changes or handwritten additions to the lease. So if you have a form lease that leaves blank what the rent is, and you fill in the rent, you want to make sure that the tenant is initialing that. That way, you're preserving that document as the official version of the document, and you won't have to deal with any suspicion by the court that you've added terms to it if the tenant accuses you of that later on. You can just point right to their signature or their initials. Also remember that after a lease is executed, you can't make any changes to that lease without giving the tenant something. In contract law, they call this consideration. You can't have a contract between two parties when you're not giving the other party anything of value. And so if you enter into a contract and sign everything and they pay you the first month's rent, and then later on down the road you want to amend that contract, that lease within the term of the lease, then you have to actually negotiate with the tenant to offer them something, or else any changes are not valid. That brings me to my last point on this slide, which is that when the lease comes to an end and you want to make changes to the lease, you need to give the tenant advanced written notice of those changes. That's the way that you make changes to a lease after the lease is signed. You wait till the lease is coming to an end, and then you inform the tenant of the changes that will be going forward upon the renewal of the lease. You can always make up a new lease at the end of the first lease term, but a lot of that can be inconvenient. So if you're going to add terms to the lease after the end of the first lease term, make sure you've given them advance written notice. Otherwise, the courts are likely to say that that's not valid because the tenant didn't have time to truly consider these changes before they held over in your property. But it's perfectly fine to make changes to a lease without any additional consideration once the lease term is over, because that's really creating just a new lease. And so what I previously talked about additional consideration wouldn't apply at the end of the lease term. All right, and a very important part of the lease, following from my previous point there, is defining what the length of the lease term is. All right, the common leasing periods are month-to-month or year-long terms. You want to be very specific also that you define what happens at the end of that lease period. You can put in various provisions here. You can have the lease automatically renew for the same period of time. You can have it just end. You can have it change to a month-to-month lease. But you really want to put that in there. If you don't, then the court is back in control. And the court will look at the circumstances of the leasing situation and imply its own renewal clause. So if you had a lease for a year, the court is likely to imply that there was an automatic renewal for another year. Same with month-to-month. If it was month-to-month, they'll imply that there's an automatic renewal on a month-to-month basis. So you don't...
Dan?
You don't want... Yeah, go ahead.
We're getting a couple of questions on the previous slide with the consideration. That's the official legal term for when you make those written adjustments, right?
Correct. Right. Consideration is the legal term for something of value. So when you amend your lease, and I see someone's asking about, well, what about a lease addendum? Yeah, that's going to be a change to the lease. And if you want to impose new restrictions or responsibilities on a tenant during their lease term, you have to offer them something of value, consideration, in order for that addendum to be valid. Now, lease addendums come in many forms, right? A lease at the outset can refer to lease addendums, and those are all part of the original consideration of renting the property to the tenant. So those are valid, but that's why it's very important to define the lease term, so that if you do have new rules or regulations that you want to put in place, that you can do it at the end of the next of that lease period. Well, right. So I guess I see one of the questions. It's a little tough for me to read these questions as I'm rolling along here, but one of the questions is, what do you mean by something of value? Well, something of value would be a difference, any sort of difference in the benefit to the tenant. So initially what the consideration is when you rent a property is that they have a certain property that they have exclusive control over, right? That's the benefit that they get. And so, maybe you could offer them a little less in rent. You could offer them, all sorts of things. These are generally things you don't really want to do. So that goes back to my point, that if you have a very important change to the lease, you need to make sure that you're either thinking ahead and put it in the original lease term, that you have the ability to end the lease and sort of restart the lease at the end of that term. And I guess I also see anti-bullying addendum. That can be a little confusing, and it depends on how it's going to be used. You could argue maybe that does benefit the tenant, but I don't think that that's going to fly. But I think you could also say that a lot of things like anti-bullying addendums are just clarifications of what the terms of the original lease are. So in any lease, there's an implied covenant that you do not disturb your neighbors, that you don't destroy the property, things like that. So an anti-bullying statute would just be defining further what your responsibility to your neighbors are. And as long as it's within reason, I don't think that would be a problem to add. So that's really not changing the lease as much as just putting people on notice as to what the particular lease means. Although you might have trouble if you're really going after trying to evict people based on something that you've added in a lease addendum. All right. I guess at the end we can add more questions, and I can address that further if people have any more information they need on that. Before I go to the next slide, in regards to end of lease term, I just caution people that the Fair Housing Act applies, and if the reason you're not renewing someone's lease or the reason you decide to end someone's lease is that you don't want to rent to them because of some sort of protected class that they're part of. For instance, they have a family and you don't want children there, or various other things that are probably more offensive. You can't do that. Just because your lease is over doesn't mean that you can just get rid of the person if the whole reason that you're doing that is because of their protected class status. That would be considered a pretense for evicting someone based on their race or ethnicity, etc., and you can't do that. So watch out that you don't perceive an end of lease term as just I can evict anybody for any reason I want. All right. Of course, your written lease should address rent. This is generally a bargain for exchange between the parties, meaning you come up with the amount. There's not much regulation in Pennsylvania as to how much you can charge a tenant. there are some local ordinances that control the amount of rent. So you have to watch out for that. That does not apply in Allegheny County here out west. You want to state the amount and when it's due. You also should, for your own sake, clarify to the tenant how they're supposed to pay the rent. And then a lot of attorneys recommend that you include a clause that says rent is due without demand, because the old case law required that you demand rent from someone before you can sue them for not paying it. It's not a situation that comes up too often these days. All right, late fees. Make sure if you're going to charge late fees, you clearly state that in the lease. I recommend that you do not use a percentage fee to establish what your late fee is. So 10% of the rent. The reason for that is you don't want to invoke the laws and regulations that apply to finance charges. Those are very complicated, and you don't want to get into that mess. Remember that your late fee needs to be reasonably related to the actual cost of the missed payment. Excessive late fees could be considered a penalty, which is unenforceable under Pennsylvania contract law. It's up for debate and up for the judge to decide what is reasonable, what is a reasonable amount of what you would have had to go after the tenant for a late payment. But if your fees become excessive, the court can strike them down, and then you'd get nothing. Also, make sure your late fee clauses are worded in plain language. Don't get tricky with how you word them so you can tack on other fees, because that also can be struck down. Utilities, make sure you're clear as to who pays the utilities, who's responsible for them, and make sure that if you're keeping the bill in your name, but the tenant's responsible, that you're providing them with a copy of the actual bill, or somehow providing them with an accurate amount of what they need to pay. This is just good practice. Make sure tenants know if they're using too much electricity. Really quickly here, there's a difference between public utilities and municipal utilities. Municipal utilities are provided by local municipal authorities, and that's a lien on the property regardless of whether the bill's in the tenant's name or the owner's name. So the owner is going to be responsible for that bill if it's unpaid by the tenant. Public utilities are not that way. I guess I have to move things along here. So let me just touch on one important issue with utilities, which is the issue of foreign load. Now, in publicly regulated utilities that come under the Pennsylvania Utility Commission's purview, they prohibit foreign loads. And a foreign load is just when a tenant's bill includes usage from another unit or from a common area. A common area could be a hallway light. It could be a laundry machine in the basement that everyone uses. It could be a basement or garage that the landlord's using for storage. And if the utility company discovers a foreign load, what they do is they transfer the entire balance into the landlord's name and keep it there until the foreign load is removed. And if that tenant is behind in their bill, all of a sudden that big bill becomes the landlord's responsibility. And the utility companies are really being pressed to look for these issues, so that is becoming more and more a concern for landlords. Make sure that when you rent the property, if the tenant is responsible for a particular utility, that they have their own line and that it's not a line that's used for other things that aren't related directly to that tenant. All right. Real quick, the Lead Paint Disclosure Act, I said I'd talk about it. Federal law says that you have to do 3 things in your lease. You have to provide the tenant with an EPA pamphlet. I've provided a copy of the website to get that pamphlet. You have to disclose if there's any known lead-based paint or lead-based paint hazards in the home, and you have to provide a standard warning to tenants about the dangers of lead-based paint. Most form leases after 1992 will have this in there, but make sure you have it in there, because if you don't, it voids the lease and there's a civil penalty. So if you have a lot of properties, you don't want to get caught up in that. This does only apply to households where the house was created in 1978 or earlier. I'm just going to skip ahead here because I see we're running out of time. I'll jump right ahead to security deposits. The Landlord-Tenant Act actually regulates security deposits. It says that you have to hold a security deposit for a tenant in a separate escrow account. You have to, or you can only charge up to 2 months rent for the first year as a security deposit. And the second year and subsequent, you can only hold 1 month's rent. Interest. After 2 years, you have to put the escrow in an interest-bearing account, and the tenant is the beneficiary of that interest. However, a landlord may deduct a fee of an equivalent of 1% interest. So for the last few years, with interest rates so low, really that has not been a concern since you're not getting enough interest to even cover the 1% fee. Return of the security deposit. You're required to provide the tenant with the security deposit after they move out if there's no damages and no unpaid rent. The tenant is required to give you a forwarding address. Once that forwarding address is received, the landlord has 30 days to either return the full security deposit or send the tenant an itemized list of the damages for which the landlord is withholding some or all of the security deposit. Failure to provide that list or to pay the security deposit could subject the landlord to double the security deposit amount. So make sure that you're getting those letters out quickly within the 30 days if you intend to charge the tenant for anything that would go towards the security deposit. All right, we'll move along here quickly to recovery of real property, the eviction process. First of all, there's basically 3 grounds for eviction. There's the end of lease term, which we talked about briefly. Generally, you don't need any other reason to evict someone. Once it's the end of their lease, you can move forward with that, except for that caveat of using it as a pretext to get rid of someone who's in a protected class based on their protected class status. Also, failure to pay rent is an obvious grounds for eviction. And then any material breach of the lease. And again, this is why the written lease is important, because you're going to look to that lease to define what are the terms of the lease and what within those terms is material. There are a few implied terms that the law will allow a landlord to evict for, even if it doesn't clearly state that in the lease. For instance, illegal drug activity is actually an evictable offense under the Landlord-Tenant Act of Pennsylvania. You can also request damages when you're evicting a tenant. At the same time, you can ask for your unpaid rent, your late fees, any outstanding utility bills, property damage. Remember, you have a duty to mitigate your damages once the tenant has left, which really means that if the tenant leaves mid-lease term, you don't get to sue them for the entire lease if you haven't attempted to re-rent it. If you've attempted to re-rent it and you can't, then you can go after the tenant for those months, but you do have to at least attempt to re-rent the property, mitigate your damages, as they would say. The procedure is fairly straightforward. There's 2 methods. The most popular, of course, is taking a tenant to the magistrate. That is an expedited process authorized by the Landlord-Tenant Act. The other process is an ejectment action in the Court of Common Pleas, generally more complicated, costs a lot more, could take longer. So I recommend, of course, the magistrate proceeding. Remember that before you go to court, you need to provide the tenant with a notice to quit. That is required under Pennsylvania law. That notice has to be in writing. It needs to be clear and explicit, unequivocal, and it should state the grounds for why they're being evicted. That notice has to be delivered 10 days in advance of filing the lawsuit if the issue is unpaid rent, 15 days if it's the end of the lease term or a breach of the lease. That notice has to be delivered personally. If you can't deliver it personally, you can post it on the property, like on the door. Posting by first-class mail does not meet the law's requirement. Now, going back to the written lease, the law does allow you to waive a tenant's right to receive this notice before you sue them. And so you want to put that in your lease if that's something you're concerned about. I will note that some federal housing regulations prevent you from waiving that right of a tenant. In order to file a complaint, you go down to the magistrate office, pay the fee. They have the form for you to complete. You detail what your reasons are. You get a hearing within 7 to 15 days. Continuances can be granted based on the discretion of the judge. And then once the hearing takes place, the judge has 3 days to send you out by mail his or her decision, which is known as the judgment. I don't know how much further we have time to get through these slides before we start taking questions, but I'll try to get to the end of the recovery of property section. Quickly, knowing how to win your case at the magistrate is very important. Remember that it's your case to win. You have to prove the facts. So make sure you have the documents necessary to do that. If you have a written lease, you need that lease. If they owe rent, you want to have a rent ledger so you can tell the judge specifically what months have not been paid. If you didn't waive the right to notice to quit, you need to show a judge a copy of the notice to quit you provided the tenant. And then, of course, for damages, you need to have evidence, photographs, any charges for labor, expenses, etc. Make sure you bring your witnesses. You can't use hearsay evidence even at the magistrate level. And what hearsay is statements by someone who's not the tenant and who is not there to testify, right? So for instance, letters or written complaints from other tenants, if their tenant is not there, if that neighbor is not there to testify, then those letters cannot come into evidence. So you want to make sure that you have the proper witnesses there to prove your case and to win your case. Judgments come in two forms from the magistrate when it comes to possession. There's just straight possession. That's where the tenant has no right to cure, and they'll be evicted regardless of whether they catch up on their rent. There's also what we call a pay and stay. If the only issue is non-payment of rent, then the judge can enter a pay and stay decision, which allows the tenant to pay off the total amount of rent owed plus the court costs and stop the eviction. Of course, you can also obtain monetary damages. And then one thing that's very important that the judge will do at the magistrate level and set in his judgment is what the monthly rent is. And that's important later on appeal. So you want to make sure the judge gets that right. Here, I guess you can look at later if you get a copy of these slides. This is just a copy of the standard judgment from a magistrate where I've put arrows pointing to the various key information on that chart. Okay, remember that the magistrate level is not the end of this process. If either party wants to appeal, they can appeal to the Court of Common Pleas. If it is a possession issue, they only have 10 days from the date of the judgment to file that appeal. That's 10 regular days, not business days. So 10 calendar days from the judgment, appeal has to be filed. If that 10th day falls on a weekend or holiday, they do get that extra day. And of course, if a tenant files the appeal, they have to pay rent into the escrow with the court while the appeal is pending. And if they don't, then you can terminate what's called the supersedious bond with the Court of Common Pleas and go back to the magistrate level and evict the tenant even while his or her appeal is pending. I laid out in more detail in this slide how that all adds up in terms of what needs to be paid there is a difference between what typically is paid and what needs to be paid by individuals who declare themselves low income. All right, after you get a judgment, then you need the magistrate to execute on it. And to do that, you go back after the 10-day appeal period is expired and request an order for possession. The constable, who acts on behalf of the magistrate, will serve the order for possession, giving the tenant 10 more days to vacate. And if that tenant doesn't leave, then the constable can come back at your request and forcibly evict the tenant. Remember that order for possessions are only good for 60 days after they're issued, and they can only be issued up to 120 days from the date of the judgment. So magisterial judgments can go stale. So if you're working with a tenant on a payment plan or letting them stay, make sure that that they're complying with whatever agreement it is that you have within the 120 days, or else you're going to be out of luck if you want to still evict them. You'll have to go back and start the process all over again. Just quickly, self-help evictions are illegal in Pennsylvania, which means you have to get the court and an officer of the court to execute on an eviction. You can't just go and change the locks. You can't terminate the utilities or otherwise interfere with the tenant's residence. And one quick thing I just want to point out about a new development in the law. What happens when a tenant has abandoned the property, or you've obtained an eviction order and executed on it, but the tenant has left personal property behind? Well, the new law establishes some rules for what happens in that situation. Basically what it says is that once the tenant has left has abandoned the property, and the law defines certain circumstances where that can be considered to have been done, the landlord needs to send the tenant a letter. I've highlighted here, and it's in the law, specifically what that letter needs to say, but it basically lets the tenant know that if they want to get their stuff, they have to contact the landlord within 10 days. Otherwise, the stuff can be disposed of. And that's what the law does. You have 10 days. The tenant has 10 days from when that letter is sent to contact the landlord. If the tenant doesn't contact the landlord within those 10 days, then thereafter the landlord can dispose of the property as he wishes. If the tenant contacts the landlord within those 10 days, the landlord has to store the property up to 30 days from the date that letter was sent. And the tenant can come by and get that property. Landlord can store the property where he likes, and the landlord can't charge the tenant for the cost of storage within the first 10 days. But after those 30 days expire, if the tenant still hasn't come by to get that, then again, the landlord is allowed to dispose of that personal property. And I just warn landlords against violating this act, because the act added that a tenant can recover treble damages, 3 times their damages, and attorney fees if a landlord violates this law. So the important part of this law for landlords is getting a letter out to that tenant before you dispose of any property that's left behind, and making sure you hold on to property for the 30 days that's required before you dispose of it. Okay, that's a real brief introduction to the basics of landlord-tenant law. Gail, I don't know how you want to handle questions.
Hi, if I could interject, Gail, it's Joyce. I think given we have 5 minutes, I'd like to see if we can extend, if you have time, maybe to go to 10 minutes after. I think
no problem with that myself.
Is that okay? Okay.
Fine.
So pass it off to Gail, but I think we usually like to stop right at 1, but I think given the interest and the depth of information and questions, so I'm going to pass it back off to Gail.
So I am scrolling back to some of our past asked questions. We had a question from Laura Blau. If one is going to do some repairs to a building while it is occupied, like restuccoing the exterior or replacing windows, can you create a clause that informs tenants that this will happen prior to renewal and that they will not get compensation beyond what is negotiated for any disruption within reason as spelled out in the agreement.
I'm not sure I quite understood that.
And Laura, if you want to unmute yourself to ask, it's *7.
Well, I guess what I understand that question, if the landlord needs to make repairs to the property during the lease term while a tenant is occupying the residence, and the landlord makes an agreement with the tenant to compensate them in some way, can the tenant try to get compensation beyond that? Is that a correct paraphrasing of the question?
And again, Laura, if you want to ask a question, just hit *7 and that will unmute you.
I think it has to do with compensation for any sort of disruption during a repair.
We can also move on
yeah,
to the
I
next.
think that.
Yeah.
Right, I would say that compensating tenants for any disruption during the repair, I do think that a landlord has to do that if the repair is something that affects the habitability of the residence or the tenant's right to quiet enjoyment of the residence. How much you have to compensate a tenant for is, a completely up in the air question that, is something that I think you can reach agreement with through negotiations with the tenant, and I think a court would uphold whatever agreement you reach with that tenant. But I do think that if the repairs are going to really disturb the tenant's use of that property, that you do have to compensate them, because going back to the original contract when it was signed, you agreed to provide them with a habitable home that they could use and have quiet enjoyment of, and that they were going to pay you rent for that. And if they've upheld their end of the bargain, even though you have to make repairs, you have to, if you're not going to be able to give them what they bargained for, you have to compensate them for that. If they're a difficult tenant.
The next question is, can a landlord require a new tenant to pay the former tenant their security deposit? Situation where a new tenant is told they must make a check out to the former tenant for their security deposit.
Well, I don't think that there's anything particularly wrong with that if the tenant's willing to do that, but it sounds like the landlord has violated the security deposit portion of the Landlord-Tenant Act, which requires that that security deposit be deposited in a separate escrow account. So this is a pretty common mistake for mom-and-pop landlords. They just mingle all their funds together, and they hope that at the end of this tenancy they still have a security deposit left, that tenant out, if that tenant leaves the property in good condition. So the landlord might want to be wary of violating that portion of the act, but they are free to negotiate with the incoming tenant various terms, and I don't think that that would be a term that's illegal.
Okay. The next question is from Paula Deacon, who I see has her hand raised. So, Paula, do you want to hit *7 and ask your question? Are you there, Paula? So the question is, are you saying that a security deposit must be returned within 30 days of receiving the forwarding address specifically, or is 30 days within receiving keys?
It's 30 days of receiving the forwarding address, or if you receive the forwarding address before they surrender possession, before they give you the keys, then it wouldn't start until they give you the keys.
Okay.
So, to break that down a little bit, if you have your tenants provide you with a forwarding address in advance of them leaving the property, right? So they gave you notice, I'm no longer renting here, I'm moving on such and such a date, and you said, okay, give me a forwarding address. Then you have that address in your possession. So as soon as they vacate, give you the keys, tell you they're gone, then the 30 days start. But if they move out, give you the keys, and they don't give you a forwarding address, the 30 days don't start until you finally get one from them. It's their responsibility as a tenant to provide you that forwarding address, and the 30-day time period doesn't start until they've done that.
Great. The next question is, what type of authorization should be used to have a third party represent landlords?
Good. Yeah, I put that as a note in one of my slides, but I skipped over it. The Magisterial District Court has its own form that they will provide you when you go in there. I believe they require you to use their form, but I can't speak for that outside of Allegheny County. You do have, for other people who might not know this though, if you're an attorney, you can represent yourself, of course, you can represent a corporation, etc. If you're the owner of the property or the owner of the company, then you can represent yourself at the magistrate hearing. But if you're just an employee of a company, you are not allowed to represent the company at a magistrate hearing unless the owner of that company signs this authorization letting you be their representative. So at the magistrate level, you can represent a company without an attorney. But if you're not the owner of that company, you need to get this authorization form to the court. And to answer the question, they have them at the courthouse or at the local magistrate offices.
All right. Should a homeowner use ejectment to remove someone who is not a tenant, such as an adult child?
That's a very good question. That comes up a lot in my practice. Ejectment ultimately would work, correct. If you don't want to go sort of a more extreme route, which is to declare them an unauthorized occupant and go through the criminal process of trying to get the police to remove them as a criminal trespasser, then an ejectment will work. But it's a court of common pleas process that can be difficult to handle without an attorney, and is certainly not as customer-friendly as the magistrate process. And the magistrate is not given a jurisdiction to remove someone who's not a tenant, like a family member. What I recommend to my clients generally is you provide the individual with a written notice telling them that they're no longer welcome, giving them a reasonable period of time to move out, and then at the end of that period of time, contacting your local police department, providing them with a copy of the letter, explaining to them the situation, and telling them that they're unauthorized and you'd like them removed. Depending on your police situation in your local area, they may or may not help you with that.
I have been told that there is an exception to the police reports being usable document, therefore exempt from the hearsay rule. Is this not correct?
Okay, so a police report is hearsay because it's a statement that's not made in court. It might be an exception to the hearsay rule if you establish it as a business document. However, you still need someone from the police department there to authenticate that document. So a landlord by themselves showing up with a copy of a police report is not going to be admissible evidence. I will tell you this, practically speaking, a lot of magistrates are going to give you some leeway on that. And if that's the case in the jurisdiction you have your properties in, then you can press your luck with that. Now remember, a police report is different than a criminal docket. If the person has been convicted of a crime, and that's the reason for the eviction, you just need to bring in a copy of the docket, because that is a government record which should be honored by the court. And a conviction of a crime is proof positive that they committed the act associated with that crime.
Can a landlord include some fee for their time as damages in the case of an eviction hearing?
Well, if the time is for them taking the tenant to court, the answer is generally no. In American jurisprudence, we put the cost on the party bringing the suit. So if you sue me, you have to pay your costs, and I have to pay my own costs to defend it. That's called the American rule. However, you can change that rule by agreement. So if your lease says that individual has to pay the winning party the cost of the lawsuit, then that's fair damages to claim. And if you have one of those leases, then you can make an argument that a magistrate might entertain that you've spent time with the eviction process. But generally, you actually have to have an attorney in order to collect the cost of your time. If you're sending a property manager, someone who's just an employee, I think it's more reasonable to bill the tenant for that employee's time. But if you're the owner or sole proprietor of the company, then it's really not something that's often granted. Okay.
Is there anything in federal or PA law that prohibits landlords from renting to individuals who do not provide Social Security numbers?
I do not think that there is.
Could something happen at the municipal level that could prevent a landlord from renting to somebody without a Social Security number?
That's a question beyond my ability to answer today, because that's obviously a question to try to limit illegal aliens from being able to rent in the jurisdiction, and that's a complicated question to answer. I can't do that today.
Okay. What should happen if the tenant does not provide a forwarding address?
Well, the landlord still has the responsibility to provide the tenant with the security deposit if there was no damages and no unpaid rent. But they don't have to go out of their way to give the tenant that money. So if the tenant shows up, resurfaces at some point, and asks for their money, then you have to provide it to them. But the act that specifically requires you provide it to them or give them the list, that, again, does not apply if you don't get that forwarding address. So you can sit on the security deposit until that tenant shows up and asks for it.
When a tenant dies and they name a person to forward the security deposit to, must we write the check to an escrow account?
I'm not sure I completely understand that question. If someone passes away, then the security deposit is part of their estate. And so, it should be administered through that process. I know they're trying to get legislation passed to clarify this type of situation in general when a tenant passes away. But I don't think that there's a requirement that you send it to an escrow account unless, as part of the probate process, the administration of the estate, they've established one, and they're demanding that all the deceased property be returned to that escrow account. So that might be what the question is about. If there is one established through the probate process, then that's where you'd want to send the check.
Maybe one more question, Gail?
Okay.
I think we're getting close to time.
Okay. So the landlord has security cameras installed on the outside of a rental house. Those information on the cameras have to be in the lease agreement.
No, I don't think so.
I guess I just had one question that I wanted to pose. One is I had emailed, this is Joyce from the Housing Alliance, that we will be sending out the recording as well as the PowerPoint presentation from Dan. Dan, is it okay if we give folks your contact information if they have follow-up questions? And then
Absolutely, that's fine.
Great. And then the other thing is wanting to know, it seems like we bypassed a few. Can we invite you back to do, and I don't mean to overtake the Southwestern PA work, but obviously if we could do a part 2, and if people, when they get the survey that will come when they sign out, if you could let us know what it is you might be interested in hearing about from Dan. This is obviously an interest to a lot of people. So would you come back and help us some more?
I would certainly come back, and I know that this was just a brief introduction, and I skipped over a lot of details. So, yeah, let me know what particular areas people want to delve into more.
Yeah, we can definitely draft a survey and give people an opportunity to ask what specific areas they want to focus on, so we can really break it down by the different points that you highlighted today. So thank you so much, Dan, for this very interesting webinar and for giving us even a little bit extra of your time. And thank you all for getting on the webinar today. We will be sending out a copy of the slides as well as a link to access a recording of the webinar itself. So if you have any other questions, feel free to call me or email me, Gail Schwartz, gail@housingalliancepa.org, or my phone number is 412-281-1137. And we'll get Dan's contact information out as well for those specific law questions, because he can answer them. Those I'm not so good at. But thank you all, and have a good afternoon.
Take care.